Welcome to my webinar on workplace testing. Thank you so much for joining, especially early on in the morning. So just by way of background, my name is Anna and I'm an employment law solicitor here at Harris. So like I said, today's session is going to be on workplace testing. I'm not going to have a presentation up on my screen. It's really just going to be a case of me chatting you through the legal considerations of workplace testing, just to keep it fairly informal. So as restrictions are starting to ease and many people are returning to work, workplace testing is certainly a hot topic at the moment amongst many employers. So in the next half an hour or so, I'm going to talk you through the practicalities of implementing workplace testing and also the many legal considerations to bear in mind, particularly if you are planning to mandate workplace testing. Now, there is a slight overlap with health and safety elements throughout. Now, I'm just going to touch on them very, very briefly because the health and safety side of things does fall outside of the scope of today's webinar. In any event, in the last 10 minutes or so of the session, I'm going to leave it open to do a Q&A session. So if you do have any questions at any point during the session, feel free to pop them in the Q&A box. And then at the end, I'll try and work my way through them and answer them as best as I can. So I'm going to start off by looking at how to implement workplace testing, and then I'll move on to discuss whether employers can demand employees to be tested. So I thought it would be interesting just before I begin to find out from everyone who's on the chat if anyone has actually implemented workplace testing yet. Now, please, if you don't feel comfortable, it's no problem at all. But if you do feel comfortable, please can you just pop in the chat a yes or a no if you have implemented workplace testing. Oh, that's great. Thank you. So it's looking like we've got a real mix, a real mix of everyone that's put their answers there. Thank you so much for sharing that with me and everyone today. So yeah, so that's great. We've got a real mix on the session today. So the starting point is really that there is no legal requirement for staff to be tested to attend the workplace. The government guidance essentially pictures it as optional and that it's encouraged. But the fact that it's optional doesn't necessarily prevent an employer from introducing it if you feel that it's necessary. So many employers are and will, like many of you there, someone said that they're hoping to introduce it this week. And you'll want to do that as an additional safety measure. And testing does bring many benefits. The main one really is to act as a measure to protect health and safety. But it can also provide confidence to your staff and any third parties attending the workplace too. However, it is really important to bear in mind that workplaces must still be COVID secure following the government guidance. So testing doesn't necessarily replace the restrictions that are already there. But this may change, like everything that has happened sort of within the last year or so. I'm aware that the government is reviewing whether COVID status certifications could come into place. And I think the government today announced using the NHS app for people to travel freely in the next coming months. So we'll really need to keep our eyes peeled to see whether the situation does change in terms of how this would affect the workplace. But as it currently stands, it's not a legal requirement. So for those that haven't implemented testing, I'm going to talk through briefly on how to do this. So the first step in terms of implementing is you really need to consider whether it is necessary for your workplace. So I'm sure you're aware, you have a duty, a health and safety obligation to ensure that your staff have a safe working environment. So effectively, the testing should be necessary and proportionate to mitigate against the health and safety concerns that you have. And whether it is necessary will be very dependent on the specific working environment and your business needs. And effectively, you would determine this by carrying out a risk assessment, which will help justify any rollout, particularly if you're looking to mandate it. But you must bear in mind that the government's message is still that people should continue to work from home where possible. And I believe this is at this moment in time, I think it's till the 21st of June in the government's road map to recovery. So you should try to continue to do this to eliminate that risk. And obviously, where it's not possible, the guidance states that the workplace must be COVID secure following the guidance, which includes social distancing, PPE, and so on. An implementation of testing can form part of this strategy, but like I said, it's really not a legal requirement to do that. In any event, the government guidance does set out different testing options that employers can adopt. So the first one, you've got an employer-led setup. So employers can set up their own on-site testing and pay an approved provider or ask employees to request a home testing kit from the NHS. You have the second one, sorry, which is a third-party provider. So you can have on-site testing, but a private provider would organise and run the testing on your behalf. And I'm aware on the government guidance, there is a list of providers that employers can partner up with. And the other one is community testing through local authority testing sites. And that's available for employers with fewer than 50 employees. And the guidance does encourage any employers to visit the local authority website to get more details on that. So based on that, there are a number of factors to really consider before implementing it, in particular whether it is actually necessary. And whether it's necessary, that will really sort of encompass the legal risks, which I'm going to talk through briefly later on in the session. But other sort of factors that you will need to consider as an employer is obviously deciding the right test, how the test will be conducted, the scope of the test, so who you will require the test from, the frequency of the test. I know the government guidance, I think, suggests twice a week. The timings of the test as well, so when staff will be required to do that. And the list does go on, but those are sort of a number of factors to consider there. So when you have decided whether it is necessary and you do want to implement workplace testing, the next step is to implement that ultimately. Now, the government guidance and ACAS recommend that you should consult with to help deal with any initial issues. So for those who haven't implemented testing, but you're looking to do so, the key is really to get engagement with your workforce. And a good starting point is to discuss with your staff first and ultimately communicate your intentions in terms of you making the decision that you want staff to be tested. And in particular, you should try to address why you believe it's necessary. So, why you feel it's necessary that they should be tested in the workplace. Um, Whether it's voluntary or mandatory. So you'll need to decide on your stance on that. And I will deal with that a little bit later on in the session. And just linking to that as well, excuse me, sorry. Thank you. Where they stand if they refuse to be tested. Looking at how the testing will be carried out, who will be carrying out that testing as well, and the practicalities involved in doing that. How staff will get their test results, the process as well to follow if someone tests positive for coronavirus, following the test, pay if someone needs to self-isolate but cannot work from home. And then from a data protection point of view, how the testing will be used, how it will be shared, if it's going to be shared with any third parties, how it will be stored and deleted as well. So those are just sort of things that you will need to think about and address with your staff as well to ultimately get them on board with the testing. Now, if you are in a unionised work environment, you may need to consult with employee representatives or trade union reps. So that's something to bear in mind too. And in terms of getting engagement from your staff, it's really going to be a case of educating your staff in terms of why you feel it's necessary, the benefits of getting everyone on board with workplace testing. And to do this, you could share credible and reliable information on the importance of testing. And ultimately, that will hopefully assist with everyone's understanding and get them on board with workplace testing. And one of the other things to consider as well is that it's really important to lead by example. So to ensure that managers and everyone that is the senior level do actually engage with the process as well. So they lead by example, and this will demonstrate to them why you feel it's necessary, that it's important. It will, get them on board with it. You should also look to having a written policy in place to confirm those details too. So setting out, the company position on whether it's voluntary and mandatory, what happens, and so on. And this is really important, especially if you are considering disciplinary action where someone refuses. Because you will need to be able to show that you have communicated clearly a policy on testing in the workplace, and that the member of staff hasn't followed that, so they breached that policy. And effectively, you would use that policy as evidence in the disciplinary process to show that they have breached that. One of the final points on implementation is that it should apply to both vaccinated and non-vaccinated staff. Now, I'm not going to deal with vaccinations in this webinar because I'm purely just focusing on testing. So it's a topic for another day, but in terms of the implementation, it should apply to both consistently. And that's purely because there is no evidence to suggest at this moment in time that being vaccinated is 100% effective and that they can't still transmit coronavirus. And that again is based on government guidance, because regardless of whether you've been vaccinated or not, the restrictions still apply. So they must still follow the government guidance on that in terms of social distancing and so on. So moving on now to dealing with positive test results as a result of your workplace testing. Now, it's no surprise, I'm sure, if someone tests positive, then they will be required to self-isolate. As an employer, you have a legal obligation to ensure that anyone who is required to self-isolate does not attend the workplace, so you must send them home. You may need to inform people who have been in close contact with them, but one of the things to bear in mind here is that you should not disclose to them the name of the employee unless the employee who has tested positive has consented to this. So you could have a chat with the employee who has tested positive first to suss out the situation and ultimately gain their consent to do that. Now, the current guidance states that a positive result from a lateral flow test should be verified with a lab test. So ultimately, if they test positive from a lateral flow test, they should be encouraged to contact NHS Track and Trace to arrange a test. If they get tested through NHS Track and Trace within 2 days and the second test comes back negative, then my understanding of the guidance is that the requirement to self-isolate will immediately end when they are notified. And if they don't have the test within that 2-day period, then my understanding on the guidance is that they have to self-isolate for that full period. But I can only assume they would take advice from NHS Track and Trace first and go from there. And I know that there are instances where some of the test comes back invalid or void. And my understanding again of the guidance is that if it comes back invalid or it's void, it doesn't necessarily trigger the self-isolation requirement. So in situations like that, then they should be advised to be retested so that you have a result there. And in just going back to positive results, then if they're unable to work from home or they're too unwell to work because they're ill with coronavirus, and then they will effectively be off sick and may be eligible to receive statutory sick pay from day one, and that's subject to meeting the normal eligibility requirements for statutory sick pay. Or if you offer enhanced company sick pay within your business, they may be eligible to receive this, but it will be subject to the terms of their contract and also, your company sick pay policy. Because the fact that they are self-isolating may not fall within the company sick pay because they're technically not absent through illness. Oh, sorry, I've just had a request just to repeat something there. So what I'm going to do is I'm just going to quickly repeat it so that Linda can hear. So if someone tests positive through a lateral flow test, but doesn't have a lab test within 2-day period, my understanding of the guidance is that they have to self-isolate for the full, I think it's a 10-day period. That's just based on the government guidance, so I would recommend double checking that if that were to happen and get advice from NHS Track and Trace on that. But that's the position, no problem. So yeah, so sick pay or enhanced company sick pay, depending on the situation there. You just as a side note, you might want to consider paying enhanced pay for any period of self-isolation. Now, there's no legal requirement to do so, but some employers have been taking this approach to try to encourage staff to stay at home. And that's just purely because many employees have been concerned that they will lose out on pay for the period of self-isolation. So it's entirely up to you what you want to do in that respect, but I just wanted to draw that to your attention. So moving on now to, I think the main question on everyone's mind in terms of testing in the workplace is whether you can mandate your staff to do it or whether it should be voluntary. Now, the starting point is ultimately that an employer does not have a lawful right to physically force an employee to take a test. So it's really going to be a case of whether a refusal could warrant disciplinary action. Now, if an employee is displaying symptoms, but they refuse to take a test, then it's likely that you could justify reasonably instructing an employee who is displaying those symptoms to be tested based on a health and safety obligation. And then if they test positive, then this obviously alerts you to the risk of transmission and you can take action to mitigate against that. And if the employee fails to follow that instruction to take a test or even to self-isolate and stay away from the workplace, then you may be justified in taking disciplinary action on that basis. And that purely comes down to, the legal requirement that an employer has an obligation to ensure that staff who are required to self-isolate stay away from the workplace. But there's also a legal obligation on an employer to inform their employee, on an employee, sorry, to inform their employer that they are required to self-isolate as well. So it does work both ways. However, it may not be reasonable for you to require an employee to be tested if they are not displaying symptoms. In particular, if the risk can be managed through other means, such as social distancing and the other, health and safety measures that are in place. So it is possible to make it mandatory, but it doesn't come without risk. Now, it's not as contentious as vaccinations, but due to the intrusive nature of the test, employers should aim for consent and keep it voluntary, and that would really be my best advice. Um, and this is just purely based on the fact that some employees may feel that it's unnecessarily invasive when they aren't displaying symptoms, especially if there are other ways, such as social distancing, to ensure that any symptomless infection isn't passed on. And in addition to this, there is no guarantee, there's no evidence that testing is 100% accurate and effective. And it does only provide a result for that specific moment in time as well. So each business's position will be very different in terms of the reasons behind the testing, and in terms of the stance that they want to take if an employee does refuse to be tested. Now, an employer could attempt to rely on the request to be tested to amount to a reasonable management instruction on the basis that it's an instruction intended to protect health and safety. So you could try to justify any disciplinary action on the basis of misconduct for refusing to follow that reasonable management instruction. But before taking any disciplinary action for refusal, you really need to consider the employee's reason for refusing and any other mitigating factors. Alternatively, if there is a contractual obligation to get tested, then any failure to consent could amount to a breach of contract. An employer could take disciplinary action on that basis, but it's unlikely that an employer will have this as part of their contract because coronavirus is so new. But also the requirement for them to be tested will again depend on the reasonableness of that. So in terms of the risk then, there's the three main types of risk, which I'm just going to talk through briefly. You've got an unfair dismissal claim for those over 2 years service. You've got discrimination claim, and that's regardless of anyone's years service, and data protection issues as well. So in terms of unfair dismissal then, this is essentially the risk where an employee with over 2 years service is dismissed for refusing to undertake a test. There could also be a potential argument that an employee could argue constructive unfair dismissal and effectively argue that they resigned in response to an employer forcing the test, effectively arguing that's a serious breach of the contract. Ultimately, it is very difficult to justify dismissing an employee with over 2 years service for a one-off offence. The refusal will need to be sufficiently serious to warrant gross misconduct. And whether refusal is gross misconduct will depend entirely on the facts itself. Just by way of information, this hasn't been litigated yet in a tribunal, so it's very difficult to say, how a tribunal would go, whether they would see it as being gross misconduct. But ultimately, the main principles are to defend an unfair dismissal claim. Is that an employer will need to be able to show that, one, they have a fair reason to dismiss, which would be misconduct, and that was the sole reason for the dismissal. The second one is that an employer had genuine belief that the employee committed that misconduct, and that they had reasonable grounds to believe that, for instance, through carrying out an investigation. And that the dismissal was within the range of responses of a reasonable employer, and that they also followed a fair process to dismiss the employee. So ultimately, reasonableness will be the determining factor in this, as the instruction must be reasonable to have the test, but also the employee's refusal must be unreasonable. So it's really important to find out the employee's reason for the refusal before considering any disciplinary action, because this will help assess the risks and also any discrimination risk as well, which I'm going to move on in a second. You'll also need to be able to show that you have a company policy in place that was communicated to staff clearly, which I touched on it briefly, because ultimately you would rely on that as evidence in the disciplinary proceeding. And given that tests are not 100% accurate in identifying positive cases, I do feel that employers may struggle to show that testing needs to be mandated as part of their risk assessment. This is particularly the case because testing does not allow the removal or the relaxation of the COVID measures that are already in place, for instance, social distancing. So in my opinion, an employer may be in a stronger position where the workplace is one which is difficult to maintain social distancing and other safety measures. And as I touched on it briefly before, you'll also need to ensure that you follow a fair and a full disciplinary process, which will involve an investigation before that disciplinary hearing. The next risk is discrimination. So potentially, an employee could bring a discrimination claim, and they could argue that the requirement to be tested could disproportionately affect some of the protected groups. So they would need to be able to show that the requirement to be tested has the effect of disadvantaging a group of people with a protected characteristic. And for those of you who don't know, there's 9 protected characteristics. So you've got sex, race, disability, sexual orientation, gender reassignment, marriage and civil partnership, pregnancy and maternity, religion or philosophical belief, and also age. And just picking a few of those, there could potentially be a medical condition that prevents a person to be tested that is capable of amounting to a disability. For instance, there could be a medical condition that prevents them from taking a sample or makes it difficult for them to take a sample, or a mental health condition that prevents them from taking the test, such as a heightened anxiety. So if someone does have a disability, you as an employer have a duty to consider and implement any reasonable adjustments. So you will have to factor this in to the workplace testing in terms of whether there are any reasonable adjustments that you can make. Potentially, I touched on it, was a religious belief. I'm not personally aware of a belief that is against testing, but it is open if there is one out there. Um, or another one could be a philosophical belief on the base on which they base their refusal on. Now, there's no definition of what a philosophical belief is, but there are certain conditions an employee has to prove to show that it is a philosophical belief. And those include things like that it was genuinely held, more than an opinion, similar status to a religious belief, and so on. So there is quite a high bar to prove, and that could be a difficult one. But because it's not been litigated yet, brought in tribunal, um, we don't know which way a tribunal will go, and it will depend largely on the facts. Now, one of the things to bear in mind in terms of discrimination is that there are a few discrimination claims that can be objectively justified if an employer can show that it was proportionate to achieve a legitimate aim. And effectively, this would be based on good, solid business reasons, which I can only assume would be a health and safety justification for implementing that workplace testing. But a tribunal will carry out a balancing act, effectively considering the aims of the business and whether they could reasonably be achieved by a less discriminatory method. And those other health and safety measures that you can put in place, social distancing, will probably be factored in to that. From a more practical side of things, HR, by forcing workplace testing, you may affect employee relations, so that may affect the employee's trust in you, which may be difficult to manage and sort of workplace engagement and so on. So that's one thing to bear in mind as well. And the other one is data protection. So by carrying out workplace testing, you are ultimately collecting personal data as a result of that. And personal data relating to someone's health is classed as special category data, which means that there are additional conditions that you have to satisfy in order to lawfully collect and process that data. And effectively, you need to have a legal basis for it. And the most relevant basis is on health and safety grounds. You have a legitimate interest to do that. And the ICO has released guidance for employers on carrying out workplace testing. And what they do is they've emphasised that to be compliant with data protection laws, an employer needs to show that their approach to testing is reasonable, fair, and proportionate to the circumstance. And in particular, looking at, do you really need to carry out workplace testing? Will these actually help you provide a safe working environment? And are there any alternatives to limit the transmission so that you're not processing that data? But if you can show that your approach is reasonable, fair, and proportionate, then data protection is very unlikely to be a barrier. It also says that you'll need to inform your staff on why and how you intend to use their personal data, which would be covered in a policy, and also recommend updating your privacy notices too. So data protection doesn't necessarily prevent you from carrying out the workplace testing, but you just need to ensure that you do have consent, and that you are GDPR compliant when using and storing that personal data. So just to summarise then on mandating workplace testing or voluntary, whether an employer can justify mandating testing in the workplace and any disciplinary action, it will be dependent on the specific circumstance, and in particular, how important the testing is to that specific working environment, taking into account the degree of risk to the people who staff come in contact with, but also to themselves as well. So looking at the particular role that they do and the nature of the work that they do as well. what measures an employer can put in place and what measures they can't put in place. For instance, if you can't maintain social distancing in the working environment that you're in. The impact that testing has on the workplace as well. As I touched on it a few times in the session today, testing isn't the be all end all. Testing isn't 100% accurate, and it does only provide a result for that specific moment in time. So this may make it difficult to justify. The reason for the employee refusing is very important. You need to understand this to assess the risk, whether it's genuine, and look at whether there are other means to alleviate the concerns as well. Now, there's no determining factor. It's completely unprecedented. It's unprecedented times. It hasn't yet been to tribunal, so it's very difficult to say which way a tribunal will go. And like I said, it will largely depend on the circumstance. And just by way of example, a real hypothetical example, if, for instance, an employee is a care worker, there is a potential that a tribunal could view the risk of passing on coronavirus to residents is deemed serious enough to warrant justify taking disciplinary action on the basis of health and safety grounds, due to the nature of the role and the work that they do. But it doesn't necessarily mean that dismissal should be the first response in an event to a refusal. A disciplinary action that falls short of a dismissal may well be seen in a more favourable light to the tribunal. But like I said, it's very hypothetical. It hasn't been litigated yet, and it will ultimately depend on the particular circumstance. So I would recommend you take advice first before you consider any disciplinary action on that basis. So just to end the session then, before we move on to any questions that you have, if staff are willing to take part in testing, it will be much better for workplace engagement, but also from a legal point of view, as there is much less legal risk than trying to enforce taking a test or disciplinary action if they're refused. In addition to this as well, when I was reading the government guidance, it does recommend that workplace testing should be voluntary and sit alongside the other safety measures such as social distancing. So just to end that then, my best advice is really to implement it with the consent of your staff and to implement it, to keep it voluntary. But keep an eye on government guidance, as I'm sure the position may change within the next months. So I hope that's given you a brief overview on the legal considerations of workplace testing, particularly for those who haven't implemented yet, or those that have and are in situations where an employee is refusing to take a test. Like I said, if you do find yourself in that position, I'd recommend seeking legal advice before you take any action, because it's very specific to the circumstance. So I'm going to hold on now for, sorry, I'm just double checking the time there, for the next 5 minutes or so. If anyone does have any questions, if you want to just pop it in the chat, and I can see how I can best help there. Okay, so I'll just have a look. So I've got one question here. Does other means include the wearing of face masks in the workplace? What considerations do we need to take from an employment law basis? So yes, other means does include wearing face masks in the workplace. And my understanding is from the guidance that it isn't mandatory, but that could be a measure that you could put in place if it's needed, depending on the outcome of your risk assessment. Okay. Look, we have one here. We're introducing testing voluntary and asking employees to test themselves and update the results onto the government portal and then show us the results. Is this classed as processing data, as we would not be storing it? Well, it depends, I guess, in terms of how they communicate that to you. ultimately they will be providing you with that information. So you'll still technically be processing that data. And it will ultimately depend on what you intend to do with that information as well. So having a clear policy in place in terms of what your employees are required to do, what you'll be doing with that information as well, will help sort of from a data protection point of view. So hopefully that helps answer that question. Are there any more questions? I mean, if you don't want to ask a question just now, that's completely fine. If you want to get in touch with me after the session, then please feel free to drop me a line, or you can give me a call. That's no problem at all, and we can take it from there. I think I might have another one. Oh, that's great. Thanks, James. Okay, so thank you very much for everyone joining. I really hope you found that useful. Like I said, if there's anything that you didn't understand, it wasn't clear, or you want to just find out advice in relation to your workplace, then please get in touch with myself or another advisor, and we can go from there, okay? So I hope you all enjoy the rest of your day. And I'll speak to you soon, okay? Thank you, everyone.